There are new twists to the crisis rocking Edo State People's Democratic Party. Justice James Omotosho of the Federal High Court in Abuja on Wednesday voided the impeachment of Philip Shaibu as the Deputy Governor of Edo State. While delivering judgment in the suit, Justice Omotosho ordered that Shaibu be reinstated to office because the Edo State House of Assembly failed to comply with due process in impeaching him. Justice Omotosho also set aside the appointment of the new deputy governor who replaced Shaibu and ordered the Inspector General of Police to provide him with needed security to enable him to resume office and perform the functions of the office until the end of his tenure. Meanwhile, the Edo State House of Assembly has appealed the judgment setting aside Shaibu's impeachment. The lawmakers have also filed a stay of execution on the judgment pending the appeal. Also, the suit filed by the impeached Deputy Governor of Edo State, Philip Shaibu, and others seeking to void Asue Ighodalo's nomination as the candidate of the People's Democratic Party, PDP, in the forthcoming governorship election in Edo State was set aside. Justice Omotosho held that the suit, being a pre-election case, was filed outside the 14 days allowed under Section 285G of the Constitution. Joining us now on the morning show to review these judgments is Mark Jacob, former Attorney General of Edo State and former legal advisor of the People's Democratic Party, the PDP. Good morning, Mr. Jacob, and welcome to the morning show.
Good morning.
Good morning. Good morning, Mr. Jacob. First, help us to clarify one thing. In the Edo PDP case, we had Justice Ekwo of the Federal High Court in Abuja saying that, the nomination process, party primaries of February 22 was invalid because 378 persons who should have been part of the process were excluded. Now we have also the Federal High Court, the Court of Justice Omotosho, now saying, look, without necessarily addressing that ruling by Justice Ekwo, saying something different and saying, no, Asue Ighodalo was validly nominated. That's one. Two courts within the same jurisdiction line saying two different things. And then number two, what is the effect of the reinstatement by the court of Justice of Philip Shaibu as deputy governor? And Governor Obaseki saying the court is lying. He will not accept what the court is saying. I thought I saw a report like that. These governors, they overrule the courts at will and they get away with it. But what is the effect, in that regard?
Okay. Thank you very much, Doctor. Let me just follow your line of interrogation. Truly, I will start by saying that it is sad that the courts are being dragged into politics. And we have judgments coming in left, right, and center. Sometimes courts of coordinate jurisdiction say different things on the same matter. But I've read the judgment of Justice Ekwo, and when it was delivered a few weeks ago, we were discussing it among friends. One of the things we observed is that there was no consequential order. Yes, he agreed that 300 or so people were excluded from the Congress or from the primaries. But he didn't make consequential orders as to the fate of the elections that took place. Rather, he said that those people should be allowed to participate in the election or in the Congress that was going to take place in February. Now, the irony of that is that he was given this judgment, I think, in June, or is it the first week of July? The election he was saying those people should be allowed to participate in took place in February. And it is elementary law that concluded actions cannot be just treated as though they are still forthcoming. When an act has been concluded, you go ahead and review a case, and then you make order that certain people be allowed to participate in a concluded act. It is more or less a cosmetic order because it is something that cannot be complied with. The congresses were concluded. The names of candidates that emerged from that process already submitted to INEC, and elections are coming to hold in a few weeks or in a few months' time. So it's a judgment that more or less has no effect because, like I said, I didn't see any consequential order setting aside the primary election or declaring that whatever took place was a nullity. Now, for the judgments that were brought up by the Honorable Respected Justice Omotosho, truly, the deputy governor who went to court was not a participant in the primary election. And the law is very clear. Unless you were one of the parties that contested the election, you don't have locus to challenge the result. So Shuaibu knew or ought to know, or his lawyers ought to know and tell him frankly that they were wasting his time when they went to court. 14 days after the act they were complaining about had been concluded, and particularly that he was not a participant in the primary elections that took place. So once those issues that are constitutional are established, the case is dead on arrival. And so I think those are the two first issues you raised, and I have answered you.
No, the reinstatement of Philip Shaibu.
Okay. For me, it's still a cosmetic judgment. Because everybody, if I was Shaibu, I would not pursue this matter, honestly. Because even before he was impeached, he was completely redundant. He was not even at times allowed to enter the office. He was completely out of government. And yes, he has exercised his right, but if they like, they can open a door for him to sit somewhere. And for the next few months, he'll be redundant. He can blare his sirens here and there, but he will not, in effect, be part of the government. And for me, I think politicians should respect themselves. If I was in his shoes, I would lick my wounds and go my way and take my life into my hands and move forward. He was somewhere before he became a deputy governor, and life goes on. The problems of Shuaibu started when he committed class suicide. You don't come in as a comrade and jump ship and join people who are not from your political family and expect that things will go well. And it is very clear that, yes, the governor has said they are going to appeal. And those, anybody really conversant with the judicial process in Nigeria, Dr. Abati, you know, that by the time the matter goes to the Court of Appeal, I was in the Court of Appeal some days back, the earliest date they gave is 2 years ahead. The Supreme Court will also not have time for you, except for political matters that are receiving quick action beyond and above every other kind of matter. The courts are chopped up. So naturally, the elections in Edo will hold in the next few months. They may still be on appeal while that is going on. And for me, like I said, if I was in his shoes, I would take my life in my hands and move forward. There is nothing lost. You have made your point. You have shown that the House of Assembly didn't do well. But as for enforcement of that judgment, I know as a fact, and if I'm in the shoes of the governor, I will appeal, and we'll take it up from there. And exactly that is what the governor has said they will do, which is allowed by law.
All right, Tim. All right, thank you so much, Mr. Jacob. Just to explain, in his ruling, in the giving of that judgment, Justice Omotosho had said that it was based on the fact that the State House of Assembly, Edo State House of Assembly, failed to comply with due process in impeaching him. Now, taking it back, and without prejudice, due respect to the justice, for the purpose of public education and enlightenment. So, when the process was done, the deputy governor was impeached as a result of what was termed as gross misconduct, which included leaking government information and, abuse of office in that sense. But also, 18 out of the 19 members of the House voted to impeach him. What was not following due process in that process that the State House of Assembly took?
Okay, in the words of the respected judge, gross misconduct is defined. And the offense for which Shaibu was impeached does not fall under that definition. I mean, leaking, and I don't know what they mean by leaking. He was part of government. If he was asked questions about activities of government and he spoke about it, I don't really know what that leaking means, that he was leaking official information. That is not part of the definition of gross misconduct as far as the judge is concerned, and I believe he's right. Nobody should be witch-hunted, blackmailed, or dealt with recklessly because you just don't like him. There are certain and clear definitions of what is gross misconduct. And once you don't bring an accusation that falls within the ambit of that definition, certainly the courts have a duty to say you are wrong. And that is what my Lord Justice Omotosho just did. You don't rush over a thing simply because you want to get someone out of the way, and you fail to do the needful by complying with the requirements of law. The House of Assembly appears to have been in a hurry to get Shaibu out of the way. And for me, sometimes it's recklessness, because if you want to get a man out of the way and you have valid reasons, it is not difficult to find an accusation or an allegation that will fall within the ambit of the law as required. What constitutes gross misconduct? It's so elementary that people ought to know.
Okay, let's dial back a bit. Don't you think there's a problem with the Constitution that gives a room for the House of Assembly that is already tilting towards the executive to determine what gross misconduct means in a case where you have the deputy governor, where the governor wants to kill the deputy governor already? I mean politically damage the deputy governor. And you give the same House of Assembly the power to determine what gross misconduct means. I mean, they'll kill and bury the politician. Don't you think that's where the problem lies? And how can we change that?
No, my assessment is that the problem lies in the failure of structures and institutions. The House of Assembly ought not to be at the beck and call of the governor. The executive ought to be independent, just as the House of Assembly is. But unfortunately, as you find in Nigeria, the houses of assembly appear to be appendages of the executive. They appear to be one other office in government house where whatever the governor decides or wants is taken hook, nail, and sinker. Nobody queries the decision or the feelings or the thoughts of the governor. Once he says jump, they ask how high, sir. And that is for me, that is the problem. Our recruitment system is so defective that we have characters in the legislature that do not understand the role they ought to play. You find them tiptoeing after everything that the executive wants. And that is the problem Nigeria has, whether at the state, at the local government, at the state, or even at the federal level. You hear people saying that they want to have a peaceful coexistence between the executive and the parliament or the legislature. That is not correct. Having peaceful relationship does not mean you abandon your duties and completely submerge yourself from being a legislative arm to being part of the executive. It's a usurpation of functions. The executive practically runs the legislative arm in Nigeria. And that is why some people are really saying that the kind of system we are running is not working and we should change it. Truly, it's not the fact that there are powers donated to the House of Assembly. No, it's the fact that the legislature in Nigeria is not performing and is not working the way it ought to work. A president or a governor ought not to be very comfortable.
In the fairness for that argument, yes, I will concede to you. But there have been outliers. It's not the norm, but there have been outliers. I think the question is, how can we, one, amplify those outliers even more? We had an outlier during Saraki and Buhari's time because he chose to be that outlier.
Yes.
And under the circumstances at which he came in. But how can we make that outlier become the norm now? Because the sad reality is that the executive hands out what the legislature gets. They buy cars for them. They do everything for them. That's it. We're having an outlier now in Rivers just because the legislature is tilting towards another political juggernaut. We've had an outlier in the case of Edo State because those lawmakers were also in the hands of somebody. So the lawmakers are constantly in the hands of somebody. If there's a political godfather that opposes the governor, they will be in the hands of. If there's a governor that knows how to play his game, and all of this boils back to money. How can we break that leash?
Thank you. Well, you have arrived at the same conclusion like me, that every day we see situations where the legislative arm of government fails to recognize its position or refuses and kowtows to the powerful man sitting in government house and surrenders its powers. Its constitutional powers are donated back to the executive, not by anybody outside, but by the characters that are occupying the positions of legislation. They hand over their powers to the executive, all because they want largesse placed on their table. And we cannot change that by law, because the law is already very clear. It defines the role of the executive and the role of the legislator. But the legislators come on board and run even without invitation. They book appointment to see the governor and ask him what does he want. Now, unless we change or we find a way of streamlining and insisting that the legislature should do its work, these issues can never change.
Well, Mr. Jacob.
A situation where the houses of assembly are appendages of the government house is completely abhorrent to democracy, is completely anti-democratic. And we cannot change anything until people agree that they will be like Saraki, who will say, look, this is my office. I'm going to implement the constitution as it is. I'll question every action that you take. But you also know that the Saraki who took that line didn't find it easy. Even Nigerians criticized him. Even Nigerians spoke against him for being anti-government. They kept saying he was fighting his own party. And so these are the issues.
Mr. Jacob, now, I need you to clarify something for me.
Yeah.
On one hand, you say, Philip Shaibu celebrating. It's just, the judgment was just cosmetic, that it will have no impact whatsoever. On the other hand, you said that, His Lordship Justice Omotosho was right to have said it was wrongly removed in the light of Section 143 sub 11 of the 1999 Constitution. That Section 143 sub 11, yes, says you can be removed if you have violated the provisions of the Constitution. But it also says that you can be removed in the opinion of the House of Assembly. So it really doesn't matter whether you violated the Constitution. If the House of Assembly, working for the governor, as it suggested, just says you will be removed, you stand removed. That's why perhaps that section 143 sub 11 is controversial. But I wanted to use this opportunity to ask you for your opinion on the Supreme Court ruling on local government ruling and all the things that have been pointed out about primary school education, federalism, section 197, section 2, section 7, all of the 1999 Constitution. What do you think?
Well, first of all, I agree, and I was happy when the Supreme Court judgment came, because I have been part of government and I know a little bit of how the local governments are suffocated and their funds are diverted and used for other things other than running the local governments. But there is a big problem. There is a section 160, 161 that talks about the local government and state government joint account. It's a constitutional provision. So, of course, the Supreme Court is supreme, and we cannot question its decision. But what do we do about that constitutional provision that provides for the joint account? Will it be reviewed by the National Assembly, or do we take it that the judgment has amended that provision and makes it illegal for funds meant for the local government to be transmuted into that account? It's something else. It's another level of discussion that maybe the local government people should approach for interpretation. Now, the issues that gave birth to this judgment are very clear. There is no doubt. Everyone in the Nigerian system knows that local governments have just been like post office boxes. They exist, but nobody is using them. They exist sometimes just to pay salaries. They exist sometimes just so that people can be elected as chairman, and after election they have nothing to do, because if a local government chairman cannot construct a culvert, he has no political value to the people that elected him. And that is what has been happening. So the judgment is welcome. Now, besides the constitutional challenge posed by the fact that there is a constitutional provision for the opening and operation of that joint account, we have also the possibility of erecting new demigods in the place of the governors if you have irresponsible local government chairmen. The problem will become more painful, because a local government chairman who is used to seeing maybe 10 million naira now has 500 million naira. If he is not checked, and like we see in the states, the legislative arm of the local governments are sometimes just young boys who have no experience in anything besides moving around with the chairman. If they are not strongly or strengthened to checkmate what local government chairmen do, honestly, we are just going to produce or reproduce bigger elephants in the kitchen, who would now take the place of governors. The recklessness we are complaining about, the diversion of public funds to individual pockets, will be multiplied by 774. And that is my real fear. What are the checks and balances available to checkmate what the local government will do? What the local government chairman, who suddenly is a very powerful person, how do we checkmate their excesses? That is my worry, and it's something we will need to look at as the time goes on.
All right, thank you. So going back to the Edo issue, as we begin to wrap up this morning, so I'd like you to explain. So what then happens to Mr. Marvelous Mobayo, who is currently the deputy governor? Because as part of the appeal, the State House of Assembly have asked for a stay of execution, but the judgment of Justice Omotosho says that not only should Mr. Philip Shaibu be reinstated, but his salaries and entitlements ought to be backdated. What then happens to our new deputy governor in this regard?
It is a creation of court orders and or a creation of the State House of Assembly. If that judgment stands, he is gone. But if there is an appeal And then there is a stay of execution, which probably you will soon hear has been obtained. Nothing happens to him. He remains in office until the judgment is either affirmed or set aside.
So he continues to receive salary? He will continue to receive salary, and in the event that, for whatever reason, Mr. Shaibu comes back, he will also be paid salary for the same job?
Well, it depends on what the people of Edo want. But truly, if he's still acting as deputy governor, he will be entitled to remuneration until the judgment is set aside. And maybe at that time, someone can ask him to refund.
Okay, well, thank you very much. I wanted you to offer some clarification, but you avoided it in the Philip Shaibu case. But in Inakoju versus Adeleke, the Supreme Court in Inakoju and Adeleke has said very clearly that gross misconduct in section 137 sub 11 cannot be at the discretion or the whims and caprices of the House of Assembly. Maybe that's why,
certainly, Dr.
143.11 needs to be explained. But thank you very much for joining us.
No, the House of Assembly cannot go outside the initial definition that it must be a constitutional breach. So they cannot run amok.
Yeah, thank you very much for joining us.